Welcome to Lecture 3 of Legal and Ethical Issue, and we have been discussing the procedural. I just want you to know that the complexity of a legal system. We talked about substantive law and we talked about procedural law, and now we're talking about alternative dispute resolution, because when we go to court, it's litigation, and our legal system is adversarial. And in contrast to other legal systems that are more inquisitorial. And the reason why our court system is adversarial is because both parties goes into court under the rights of the Constitution, where I'm a plaintiff and I have a right not to be called names, for example, and the defendant has a right to say, hey, they were not bad names. What's the matter with her? Because the defendant will not know if that was offensive to the plaintiff or not, and vice versa. In court, we litigate law only. Hearsay doesn't come in only if there is a law, only if there's a legal action, only if there's a right that we are arguing, only if there's something that it's protected by the law, a statute. And litigation is very expensive, it's time-consuming, and sometimes it takes 4 to 5 years before we resolve the cases. And this is why in the last 50, 60 years, we more and more are using alternative dispute resolution, which is a way to resolve issue before you go to court, and more in an amicable way. And this is an example of what I'm talking about. This is how typical a lawsuit is, and all the different stages. It's overwhelming, and I just put this chart just to give you an idea, and the paperwork and the motions, and even when a person is found liable, then we have a hearing separate to find out how much liable, and if there's more than one defendant, this goes on and on. So again, very, very expensive, and it takes a long, long time. Where in mediation or arbitration or alternative dispute resolutions, we have 3 categories: negotiation, mediation, and arbitration. And this is different from the litigation. A negotiation is a process in which we attempt as attorney to settle the case before it goes to trial. There's been a situation where we were all ready for trial, 9 o'clock, and we still decided we were able to settle the case. A trial costs anything from $20,000 to $30,000 more. And it's very time-consuming. It's time-consuming for the judges. The judges do not like to go to trial. They love their attorneys that can settle. And it's very, very interesting. And why? Because even if the judge gives us some suggestion how to settle the case, we have to go back to the client. And the client has to say, okay, I settle. Or the client might say, nope, I want to go to court. I want to go to the final. I want to make sure, I want to do what the judge tells me to do, and not what the judge told you that maybe that's what's going to happen. Because after all the facts comes in, there might be a different decision. Mediation, oh, that's great. I'm a mediator. A mediator does not have to be an attorney. I just happen to be a mediator. And a mediator is very great because they don't have to write opinions. They try to resolve the dispute amicably, like what would make you happy, and then I will see one party. Sometimes I would ask the other party to leave the room, and then I will ask the defendant to come in and say, what would make you happy? What would be a fair resolution? And it's very interesting because many times then the plaintiff who says to me, oh, if they just apologize to me, I would be happy. I don't need money. I don't want this, but the way he treated me was terrible. So if he just apologized to me, and I would go to the defendant if it's a corporation or an employer, and he says that's all they want is an apology. And sometimes that solves the issue. Very, very interesting. What is an arbitration? Well, the arbitration is even more interesting in a way that the arbitrator writes an opinion. The arbitrator, again, does not have to be a lawyer, but most of the time they are. But he does have to be an expert in the area that he will be arbitrating. And there has to be an arbitrator clause in the contract. There has to be, when you have an agreement, both of you agree that if there is any dispute, you go into arbitration. There has to be a clause in the contract. Mediation does not have to be a clause in a contract. The judges sometimes suggest that we go to mediation before we go to trial. Negotiation, we already are ready for trial, and we settle the case many, many times before we go to trial. But an arbitrator has to write an opinion, and it has to be a clause in the contract. And the clause will provide that any dispute that arises under the contract will be resolved by arbitration rather than the court system. Party can also agree to arbitrate a dispute after a dispute arises. And there is nothing to do with law. The nice things about alternative dispute resolution is ethics comes in, hearsay comes in. The arbitrator or even in mediation, you know, I don't think that's a nice thing that you do, a company. In a court of law, we don't talk like that. It's more like, what's going on? Is that a fair thing to do? Because again, remember, justice is not law. You can have law without justice, but you cannot have justice without law. And in this situation, you can talk about fairness, and you can talk about what will please a person or how to end the resolution. So it's very interesting. And we're going to discuss this again on our discussion board. Thank you.